Okay, so hello everyone, morning, and welcome to our week 7 colloquy. This is the first half, which we will cover in Tumba. Today we're going to focus on chapters 11 and 12, half of chapter 12, and the rest hopefully is going to be done in Springfield. Now we were just talking about some management issues, and we want to actually start this lecture from next week. We want to start this lecture from 9 o'clock. Or colloquy from 9 o'clock, which means that we will have from 9 to 11. Okay, so we'll do like our regular colloquy from 9 to 10. There will be a 10-minute break, and then we will have from 10:05 until 11 our tutorial. Or we might do it a bit different so that we'll have maybe just like half an hour tutorial, but it will be more on the colloquy. All right? So the people online, if you are listening, and I will put something to that effect as an announcement. From next week until the end of the semester, we'll start at 9 o'clock instead of 8, just to make it easier for everyone. All right. Now, another thing I want to talk about, of course, you have submitted your assignment by now, so expect that you will get the results in early September. So I don't mark, as you know. So there are 7 markers going about it, doing the marking at the moment. And if you get your mark and you're not happy with it, you need to come back to me. So if you think, just like an appeal process, right? It's not because you don't like it. So there has to be a reason. You know, if you look at the rubric and you see that there's something missed or not enough details in the comments and so on, come back to me, please. And I will see what I can do with the markers, and then I will moderate if need be. All right. The last one we're going to do, of course, is going to be your second online test. So this was the written assignment, week 6. We're in week 7. And the last thing you're going to do is in week 15. So this is just before the exam period. One of you asked a question about the exam. When is the exam going to be? Well, we don't know for sure. All we know is that it's going to be during that exam period, starting from the 23rd. You will get something on your study desks usually after the break. Have you received anything yet? No. So after the break, you will get hopefully an email saying this is when the exam is going to be and this is where your exam is going to be. And of course, you will have as well some sort of process around if you need to change it and so on. Okay. So we're here now. We are in week 7. I'm going to continue, as we said, on contracts all the way until the end of the semester. Until the penultimate week, until the last week actually, which is week 10, and we'll do agency in that week. Then you'll have a 2-week break. When we come back, I'm hoping that we will do some revision in terms of final exams. So we have some final exams or study desk. If you want to, you could actually start looking at that during the break. And I will take you through some simulations as well and some case studies and so on. So it should be fine. We might even go through part A questions. If you want to, we can probably go through the part A questions from the final exams that we have on study desk. So I'm talking about these final exams. These 4 final exams. So your exam for this semester is not going to be much different from these. I will give you a briefing later on after the break. So we will have more about the structure of the exam for this semester. Any questions? Yes? I'm more worried about it. You should be. So someone's saying, Luke is saying, I'm very worried about part B of the exam. So let's just recap what we are doing here. I told you that this is a law course, right? But you are not law students. And I know that, and I appreciate that fact, okay? However, I cannot really give you an A or an HD without you really knowing what legal analysis is. So part B of the exam is legal analysis. 35 marks. 15 marks is part A, which is going to be multiple choice. Should be very straightforward, very easy. Part B, yes, is going to be legal analysis. And as I said, most of the stuff that you're going to do here is going to be very, very, very easy. I mean, you have done your test 1, yeah? Very easy. The assignment, you will come, when you get your results, you'll see. Test 2, same story. So it's very, very easy. It's supposed to be. But for the merit, so I can stamp, yes, this person is actually an HD in law, at least at an introductory level, you should still be able to do that critical thinking. There's no escaping that. But here's the good news. The exam is going to be very, very similar to these exams, and I'm going to take you through these exams, especially part B.
Have you got the answers to these exams?
I will give you the answers. That's what I'm saying.
Oh, okay.
Not give you the answers. I will take you through the questions.
Yeah.
So we're gonna open a Word document, and I will show you what you need to write and what you need to leave. So we'll take a whole 2 hours answering one question maybe. Okay. Any other questions? So don't worry about that. You're in good hands. All I'm saying now, focus on the second test. That's what's left for you. Just the second test. Make sure that you print out your questions if you haven't done so yet. And remember, that's going to be at the very end. You don't have to wait until the very end to submit, right? But it is till the very end. So this is where you would go. Due on the 20th of October. You just download your questions like you did for test 1. And then you're done. We will worry about the exam after the break. Okay. Okay, if there's no other questions, we will commence on today's colloquy. Yes? Great. So, as I said, we're going to continue all the way until the last week, week 10, before the break, working on the classical theory of contracts. So today we're going to cover chapter 11, which is going to talk about the consent capacity rather, and then chapter 12, which talks about genuine consent. We'll just cover mistake and misrepresentation from that chapter, and the rest is going to be done in Springfield. Now, just to make sure that you understand where we're going with this, I want to show you the analytical structure from chapter 7. So let's just quickly look at chapter 7 and the analytical structure there. Page 194. So we have done now the first analytical structure, which was talking about, so maybe we can just go to 193 as well. Okay, so we said there are 2 analytical structures we're going to go through for contracts. And you have now a Word document also on study desk under announcements, which is your notes. Use that as a template that you can take with you to the exam. So the first analytical structure talked about the existence of a simple contract. We said a simple contract is a contract that requires consideration. And there are, of course, exceptions under what we called promissory estoppel. We didn't call it. We will come to that. Actually, I talked about that, not here. I talked about it in Springfield. So you remember that this is blended learning. So you need to jump online and look at what we said there. The first thing that you need to look at is whether there's an agreement. We said agreement traditionally requires offer and acceptance. The next one was intention to create legal relationships. And we said that there are 2 situations. One is your social arrangements and one is your business arrangements. Okay? And we said under social arrangements, there's a presumption that there's no such intention, which could be rebutted on the evidence. And we said if it's business arrangement, then there is a presumption that you intend to create a legal relationship. Then we talked about consideration, and we said that's the price you pay for the promise of the other person. In a unilateral contract, it will be the conduct that you performed something for a reward. Okay? So you've gone through all of this, and you found, yes, we have a simple contract. Great. Now we have to see whether this simple contract is a valid contract. So that's what we are doing today. So this is the next analytical structure. The starting point is to see whether the parties have full capacity to contract. That's what we're talking about in chapter 11. Okay? Then we're going to go on and talk about whether these parties have genuine consent to enter into this contract. Today we're going to talk only about 2 things, mistake and misrepresentation, and then we're going to continue on things like duress and unconscionability when we look at it in Springfield. And later on, we're going to continue with illegality, whether the contract is legal, and finally, some notes about form, whether the contract needs to be in writing and so on. All right. So that's where we are. I'm going to start talking about some common law rules, and we'll see how these have been modified by legislation. Okay. So what are the common law rules regarding contracts entered into by infants? Okay. And when are such contracts valid, voidable, or void? So there's something called an age of majority, and that's given to us in a number of acts based on the jurisdiction. So if we go to page 281, you will see a list that gives you the age of majority legislation. Okay. So full contractual capacity from the age of 18. You can have a look at that. It's table 11.1. That's what we mean by infants. Infants are below that age, the age of majority. And when are such contracts valid, voidable, or void? Now these things, valid, voidable, or void, you can look at again on page 195. So just in case you've missed that as well. So this is what we mean by, it's about enforceability, and this is what we mean by valid, voidable, and void, okay? Plus the other things. Just remember, you can always go back and check on what that actually means on that page. So, when is a contract, so I always refer to contract now by the letter K, just as a shorthand. So in your exam, yeah, but we use K. So every time you want to refer to it in the exam, you can use a K. I understand what you're talking about. If a contract for necessaries or beneficial contracts of service and the price is reasonable. So if you are an infant, so below the age of 18, you enter into a contract, that contract is enforceable. So the person that sold you something can enforce it against you, and you can enforce it against them if two things are satisfied. The price is, so these are the elements, right? The price is reasonable, and it has to be something either for necessaries or necessities and beneficial contract. We'll look at some examples of what that actually means. Okay? This is both a question of law and a question of fact. All right, so this is where you can actually enforce the contract. Some contracts are voidable. So you have the election, you have the option of repudiating the contract as an infant. Okay? And these are usually things like acquisition of interest in property, of permanent nature, or a continuing obligation. We'll look at that, some examples. Or the contract could be void. Okay? So the contract binds the other party and covers purchases of non-necessaries and trading contracts, but are not binding unless ratified by the minor after attaining majority. Okay? Okay. So what do we mean by goods of necessities, or when are goods necessaries? This is on page 282. So again, these are the elements. To be successful, the plaintiff must be able to establish the following. First, are the unpaid goods or services capable of being necessaries? This is a question of law. Okay, so this is a question of looking at what's being sold and whether that's something that would be considered a necessary. So it's still abstract. Then you talk about it. Are the goods or services necessaries in the particular circumstances? So now you have to look at the infant themselves and see if what's being sold is in fact a necessary for them or not. This is a question of fact. Okay? All right. Now remember that if you are paying in cash, you are bound. Because usually when you're paying cash, you're not going to pay $100,000 in cash. What you pay in cash means that you're paying for things that more likely than not are going to be necessaries, and that's why we say that that contract is already valid. Okay? Now, as we said, there were some statutory changes to the common law, especially in New South Wales and in South Australia. Okay. So the first one was the Minors Act in 1970. Okay. So they made the infant liable in contract, provided that they are able to understand. So let's just recap a little bit and go back a little bit and talk about what we did in the existence of a contract. We said a contract exists if there's an agreement, if there's an intention to create a legally binding relationship, and if you have consideration. What we are talking about here puts a question mark on the agreement. So we're going back to the first element and saying, is there really an agreement? So my point is that this is about the ability to understand. How could there be an agreement if you don't understand? There could be an offer and acceptance, and you look at it and you see, yes, I want to sell you this pen, and you say, yes, I will buy it for that price. But there's no agreement. Why? Because this person doesn't understand. So we're going back and saying, how did this affect this issue of agreement? If there's no agreement, then there can be no contract. The agreement doesn't exist. Sometimes the agreement is defective, in the sense that because of the vulnerability of this infant, the person who doesn't understand, we see later that it also applies to people with mental illness, for example, or people who are intoxicated. They don't understand. So we give them that option to say, well, this is what you have done previously. Are you still happy with this contract, or are you going to get out of it? So that's the three things that we just talked about. And this was put into these acts. So the act really basically says the infant is liable, just like everybody else, provided they have the ability to understand. Because if you understand, then we know that there will be an agreement. Okay? All right. So it's about equity. The courts are given power to ensure that equity exists, fairness between the parties. And the same thing was done in South Australia with another act from 1979. Okay? Here the court is more active, so you need prior approval from the court to enter into a contract which the infant would not otherwise have legal capacity to enter into. Okay? And the court may appoint agents to ensure that the interests of the infant are looked after. Okay. So if you want to know more about those jurisdictions, there will be more in the textbook. I'm not going to go through that. What are the common law rules with regards to capacity to contract with respect to the following? So I'm leaving infants. We're finished with infants. We're going to talk about other capacities. What about corporations? Okay. So remember we said that a corporation is a legal person. Not a natural person, but a legal person. So we deem them to have the capacity of a natural person to contract. So they have full capacity. They understand. Okay, they have full capacity. But who's really exercising that capacity? It's the brain of the company. So the executives, you know. So it's those individuals who have the company's express or implied authority and are acting on behalf of the company. This is the Corporations Act. We're not going to go through the Corporations Act in much detail, at least in this course, but that's something to know. All right. What about people who are mentally ill? Okay. Or those who are under the influence of alcohol or even drugs? If the person can establish that, first, they did not understand. You see, it's about understanding what they were doing at the time of contracting. And two, this is important, the other person was aware of their disability, then this contract is voidable, can be set aside at the option of the mentally ill or the intoxicated person when they become mentally sound or sober. So it's voidable in the sense that when this person becomes sober, or they are not mentally ill, if they are in a state of mental illness in perpetuity, then that wouldn't apply, of course. But the assumption is, if these people revert back to a state where they understand, then they are given this option, or they can elect to whether they want to go with this contract or they want to terminate the contract, okay? Repudiate the contract.
So what you're saying is, if people are mentally ill and the other person knows about the disability, that contract is voidable.
Yeah. So two elements that need to be satisfied. So if someone is, for example, mentally ill, and then they found out that someone sort of got them into a contract to buy a car or a house or whatever, they can go and say, I'm not going to carry out my obligations under this contract. Why? Because at that time, I didn't understand. So the evidence, of course, is the problem. How you can establish that this mental illness actually meant that you didn't understand. Okay? And the second one, so this is the easy version, but it's the evidence that will get you every time. It's very hard to get the evidence. I mean that's what the details are so, But that's what you need. You need to prove that you didn't understand and that the other person was aware of your disability. Because of the way you're acting, or they know you, they know the condition and so on. Okay. That's it. That's all I want to say about chapter 12. We'll go back now after we finish up the summary for chapter 12 and look at some examples, all right? Let's then carry on with the second part of our analytical structure. Yes, we're done with chapter 11. So now we're going to move to chapter 12. And I will come back to chapter 11 and do some case summaries. Okay? We'll discuss some cases. So, again, chapter 11 is step 4. This is about the capacity. So, if you get an exam question, okay, and one of the parties, remember we said we always start who the parties are. If one of the parties is a corporation, okay, or one of the parties is mentally ill, or one of the parties is intoxicated, or an infant, you have to remember that there's an issue in relation to capacity. So if you are asked to advise the infant or the corporation, whatever, corporation of course is a different story because they have full capacity. Okay. Now there's also an issue with relation to bankruptcy. You can look at that on your own. But that's what I want. If the scenario throws up something in relation to capacity, you can spot it. Now I want to go on and talk about consent. It's the same story. If I, for example, make a mistake, and we'll talk about mistake in just a minute, and I decide to buy something thinking that it is, so I want to sell you a car, and you want to buy the car from me. We both want to buy and sell this car. But it happens that this car has been destroyed already. Stolen or destroyed, or it's non-existent. Okay? Okay? That means we both committed what's known as a common mistake. And that again goes back and puts a question mark over what? The agreement. Is there an agreement in this case again? And depending on the type of the mistake, you'll find that it could actually make the contract void. There is no contract because there is no agreement. So we found that later on, right? There was an offer, there was an acceptance, we're very happy, but then we discover that there's a problem. What's the problem? We made a mistake. So how is that going to affect our contract? That's where we're going with this. Okay? All right. So let's talk about some issues in relation to mistake. So what is the effect of a mistake on a contract? Okay. If the mistake is classified as a common or a mutual mistake, okay, that contract is void. So it cannot be enforced. So you can't go to court and say, I want to enforce the contract. if the mistake is a unilateral mistake, so only one person made the mistake, right, the contract could either be void or voidable. We'll look at examples. Okay. And also just remember that the courts are usually reluctant to interfere or intervene, even when there's a mistake, out of efficiency. Okay? So they want to leave the parties to what they have agreed on, unless there is a clear instance of common or mutual mistakes. All right. So what do we mean by that? Notice how the last three categories, the last one is called non est factum. It's a defense, okay, it's a rule. But remember that if you have any of these three, mutual mistake, unilateral, or non est factum, you have no genuine agreement. Okay? You have no genuine agreement. Which means what? If there's no agreement, the contract doesn't exist. If the contract doesn't exist, then the contract is void. It could be voidable under one of them, which is unilateral. We'll talk about it. But that's what you need to understand. This kind of defect means that we don't have a genuine agreement. We don't have a genuine agreement. We don't have a contract. Common mistake is not as dangerous. Okay? But, so there is an agreement. Okay? But there was a common error to the existence or identity of a subject matter. So this is voidable at equity and maybe also void at common law. Okay? We'll look at examples and how this works. Let's start with simple examples. So let's look at common mistake. Okay? As I said, there's a contract to sell a car, okay? A K to a car, which, unknown to the parties, have been destroyed prior to this contract being made. Okay? So I want to sell you a car, and you want to buy the car. We agreed, offer, acceptance, everything is fine. But then we want to deliver. We realize that the car is not there. Okay? That's a common mistake. Why is it a common mistake? What is the mistake? I made the mistake of what? Believing that the car exists. You made the mistake, same mistake, that the car exists. That's why it's common. You know, like when you are in a building and there's like a common area, so everyone uses the same common area. That's what we're talking about here. It's the same mistake. Both parties are looking at something and they're both thinking the same thing, and the same thing they're thinking is wrong. Yes?
When a car could go to as far as selling a house, but the house was destroyed for some reason.
Absolutely, absolutely.
So it can go. Well,
Anything, any kind of mistake. The most important thing is that I believe a set of facts, if you want to abstract, the set of facts could be the existence of a car, the existence of a house, and you believe in the same set of facts. We are both under the same wrong impression.
So going back to what I was saying again with the house example, if a retailer, they believed the house was in good condition and the buyer did, but the night before the contract was made, someone suddenly torched it by accident.
Mm-hmm. Yeah.
That could make it.
That contract is going to be frustrated. We're going to talk about frustration later on. Okay? For now, let's just say that from the very beginning there is no house. The house has been torched, long time ago, and when we started negotiating, there was no house.
So it has to have been destroyed long before any contract was made.
Yeah, because sometimes if you go through the contract and the house is destroyed afterwards, that could end up becoming under. So the contract is going to be discharged from that point on forward. So if the fire happened yesterday, from yesterday forward, that contract is discharged, meaning that I don't have any rights and obligations under the contract, and you don't have any rights and obligations under the contract. Okay? What we're talking about here is simply that this thing doesn't exist. a unicorn. Okay, I want to sell you a unicorn. You want to buy a unicorn. You don't know what a unicorn is. We think that there's a unicorn. Okay, and then we go looking for it, and there is no unicorn. That's the kind of thing I'm talking about.
I want a unicorn.
So let's assume that we are both, not intoxicated. We know what we're talking about, but still, there is no unicorn. All right. Yes? Let's look at the second type called mutual. Mutual mistake. Okay? So, involves a mistake by both parties concerning a material fact that is important to the subject matter of the contract, so there's no genuine consent. Okay? So when we say material fact, we're meaning a fact on which things would turn. So an issue would turn, i.e., for example, whether this contract is valid or void. Okay? And we're saying it's mutual, okay, from actually the etymology mutation. Okay? So we're not talking about the same thing. So, example, A has agreed to sell his car, a Holden. I agreed to sell a car, a Holden. But B believes that he's going to buy A's car, which is a Ford. Okay? So I believe B wants the Holden, and B believes I'm selling him the Ford. Yes?
So is that just a case, well, going back to you say if the, you said if one person didn't understand, like could that just be a simple case of someone doesn't know a lot about cars or something?
Yeah, it could be, but my point is, I'm talking about something, you're talking about something else. Okay? I'm talking about something, and I think that's what you want, and you're talking about something else, and you're thinking that's what you're going to get. But it's not the same. We're talking about two different things.
And again, this could range to any form of a thing. It doesn't just have to be cars. It could be.
So the key point, it has to be important to the subject matter. We'll look at examples, more examples. All right? The last, third type of mistake is unilateral. Okay? So only one party, okay, being mistaken about a material fact regarding the subject matter of the contract. So again, there's no matching of offer and acceptance. You see, it goes back to the agreement. An example, A contracts with B, thinking B is C. So I want to contract with Luke, but I think Luke, for example, is someone else who is maybe a property developer. I think Luke is someone else, and I'm contracting with him. Maybe we are just exchanging emails. Okay? B knows about my mistake. So Luke knows that I think he is a property. I think you're Trump, let's just say. Okay?
Oh.
You are a property developer, and I'm emailing you thinking that I'm dealing with Trump. You know that I'm thinking that you are Trump, and you don't do anything about it.
So you think I'm Trump, but I'm not Trump?
And you know that I think I'm making this mistake. You know it, and you don't know anything about it. So you keep playing along, all right? So that's when you take advantage of my mistake, basically. So we'll see how that affects the contract. The last thing I want to talk about in relation to mistake is non est factum. So it's not a fact, basically. So what is the effect of a mistake on a written document? Remember, this is about a case of a written signed contract. What is the effect of a mistake on a written document, and what is the operation on the non est factum rule? Okay. Again, this is defense. Okay. If you succeed in this defense, again, the contract is void. Why? Because again, you can prove that you didn't understand what you were doing, and if you didn't, just like an infant, right? Or an intoxicated person in chapter 11. Same thing. So I'm saying to you, I didn't understand. And if I don't understand, how could I agree? Even though there was an offer and acceptance, there is no agreement. That's the argument. Now you need two things. If you want to argue this, the person must believe that the document they signed is radically different from that that the party believed it to be. Okay. We'll look at an example. Okay. So the mistake must go to the fundamental nature of the document and not its contents. We'll unpack it a bit more. there must be an absence of carelessness or negligence in the execution of the document. So if you, the person who wants to rely on this defense, were negligent, you didn't do your due diligence before signing the document, or you were careless, what I'm going to sign, I don't care, I'm just going to sign it. You can't go and then say, I understand. You should actually do your homework, and then you can say, I still didn't understand. All right. So again, 2 elements. So everything with elements, yes? The first thing you have to prove is that the document is radically different from that which the signer expected, and failure to read and understand was not due to carelessness or negligence. Okay. I will move on now to something else, which is misrepresentation. We have seen misrepresentation before when we talked about negligence, in particular negligent misrepresentation. This is a bit wider, and you'll find that there are 3 different types of misrepresentation. Now remember, we call it misrepresentation because it's not really a term of the contract. It's not part of the promises that we exchanged under the contract. This was something before. Maybe it induced you to sign the contract or enter the contract, but it's not really in the contract. So what can you do about it? So let's talk first about fraudulent misrepresentation. There are 2 things, fraudulent and innocent. Let's talk about fraudulent misrepresentation. So as you see, it says fraudulent. So the first thing that comes to mind is fraud. And you go back and look at criminal law. Okay? But that's criminal law. I'm trying to look at it now from the perspective of contract law. Okay? So there's a false statement. And it's a false statement of fact with a guilty mind. Remember that guilty mind, the mens rea from... So the guilty mind. What's the guilty mind? Either knowingly or without belief in its truth, or recklessly, or carelessly as to whether it's true or false. So the person who made this statement to you made it with one of these things in his mind. That's the guilty mind. They know that this is not true, or they don't care whether it's true or not. Just make it. So, with the intention, you see, to induce a person to enter into a contract. And which in fact did induce you to enter into the contract. And after it induced you to enter into the contract, sign the contract, and become bound by it, you suffered a loss, an economic loss. Okay. So what is the remedy? We talked about this in chapter 23. Okay. You go back and look at chapter 23, and you'll find that there's a tort called the tort of deceit. Okay? So you can get monetary compensation, what we call damages. Okay? You can rescind the contract, so bring the contract to an end, as well as get damages at the option of the injured party to the contract. So you can elect what you want to do, whether you want to take it as rescission or you want to do it as a deceit. And most importantly, not to forget, if it's an exam question, that there's also something under the ACL, okay, the Australian Consumer Law. Okay, I'm not gonna push too hard on that part, on those sections, but it's in your textbook, 1 page or 2 pages. So have a look at that as well. So in your notes, if something like this comes in the exam, you can't just talk about tort. If you're advising someone, you have also to talk about the rescission of the contract, and you have to talk about the ACL. What kind of remedies they can get under the ACL. By rescission, again, I mean that we rescind the contract. We'll talk about that more in chapter 16. But it means that you can bring the contract to an end. So you will not be responsible for your liabilities under the contract. All right. So that's fraudulent contract, fraudulent misrepresentation. What about if it's innocent? What's missing now? The guilty mind. The guilty mind is not there anymore. So the maker of the statement of fact believes it to be true. Genuinely believes it to be true at the time of making. So there is a lack of intentional deceit. If there is lack of intentional deceit, you can't talk about fraud. So it's innocent. So you cannot go under tort law and argue something like the tort of deceit. Okay? So what kind of remedies are we talking about? No remedy in tort. Okay? There's a right in equity, though, to rescind rescind the contract, so end the contract, or resist an action for specific performance. So if they want you to do your part of the bargain, you say, no, I will not, because there was this innocent misrepresentation. Okay? There's also remedies under the ACL. Okay? So the key difference between innocent misrepresentation and fraudulent misrepresentation is the idea of torts. If there's fraud, you can go and talk about a tort like the tort of deceit. One more type. Okay. I think that we've covered this enough. So this is the left-hand side, talks about fraudulent misrepresentation. We talked about the intentional deceit and the torts. Okay, you can get damages in torts. This is the left-hand side. The right-hand side talks simply about innocent misrepresentation. So there's no remedy in torts, but you can always go to the ACL in both cases. Okay. Now, a third type of misrepresentation is negligence, or negligent misrepresentation. We talked about this before. It says the maker of the statement, again, innocently, but carelessly. Remember, negligence is not an intentional tort. Remember, negligence is not an intentional tort. You don't have an intention to harm someone, but you're careless. You're negligent. So there is no intention, so it's innocent, but carelessly, okay, makes a false statement. Okay? And as usual, the innocent party relies on it, and because of that reliance, they end up suffering damage or loss. So now you can still go back and talk about the tort of negligence, okay? And you can rescind the contract. You have seen this before, right? So if you go back to this page, page 314, you'll find some stuff about the elements in relation to what you need to do to establish negligent misstatement. Okay? So, special relationship, serious relationship, or business nature. Okay? You issue the statement and you know that it's intended to be acted upon, and they do act upon it, and they end up with loss. So again, you can go back actually to page 177, back all the way to chapter 6, and talk about, where they talk about this negligent misstatement. Okay. So you can either go to negligence, so argue exactly what we have here from page 177 from chapter 6. So we say we have negligent misstatement. You can rescind the contract, okay? And there's also something under the ACL. So you can go and look at some of the sections there, like section 18, that will give you also damages in that regard. Okay. So my point is that if you find something like this in the exam, you need to remember that misrepresentation has 3 different analyses. It could go under, you remember those chopsticks we talked about? You could go under fraudulent, you could go under innocent, or you could go under negligent. All right. So again, what's required? We said that you need a special relationship. Okay, in addition to normal elements required to succeed in negligence action, so you need to look at duty, breach, and damage, plus this special relationship between the parties. Nothing new. This is exactly what we talked about in chapter 6. All right. I will now switch back to chapter 11, and we start looking at examples all the way from 11 and 12, and then we'll move on to do our tutorial. So let's go back to page 282.
Oh, wait, to amount to negligent misrepresentation, you need duty, breach, and what else?
It's the same thing we talked about in negligence. What are the three elements of negligence? You have to have existence of a duty of care, breach of that duty, and causation. So causation includes damage. So there has to be actual loss or harm, okay, and there has to be actual causation, and you have also to look at remoteness and the idea of scope liability. Factual causation and remoteness. All right. Let's start with this case, 1961. Okay, South Australia. Boychuk. Anyone knows how to pronounce these Polish names?
Boychuk, actually, I've got
Okay. Boychuk and Grigorchevich. So I apologize if you're Polish and I'm not pronouncing them properly. All right. Grigorchevich, an 18-year-old Polish girl, okay, had a good job in Poland, but still wished to immigrate to Australia. And this is in the 1960s. Imagine. She asked a relative, Boychuk, to forward her passage money, which she would repay. After coming to Australia and getting a job, she failed to repay Boychuk.
They didn't really establish how long she had to pay her.
So the key point is that they wanted an agreement where she gets a loan and she has to repay that loan. She did not repay that loan. Okay? And believe you me, sometimes you hear stories. Yeah? Anyway, we're not going to go there. Sometimes $6 could be an issue. All right. Was the passage money capable of creating a contract for necessaries? Why is that important? Why are they going with that? You see how the legal issue was framed? That's what you need to do in the exam for part B. Was the passage money capable of creating contract for necessaries? Why is it a necessaries issue here? Because one of the parties is an infant, right?
But she's over 18, isn't it?
Yeah. So at that point, they assumed probably that before she came here, she was under 18, and when this contract was made, she would have been qualified as an infant. Okay. That's the first thing. Why necessaries? What changes if it's necessaries or not? If this money was necessary for her, then the contract would be what? So you're trying to protect her. She needs the money. Okay? And of course you have to protect the person who gave her the money. But if it's for necessaries or necessities, the contract would be valid. There's nothing wrong. This contract is valid, it's enforceable. What if they are not necessaries? What would happen?
The contract
would be void. Okay? So this is where we're going with this, you know? So we have to decide, is it necessaries or not? What did we say we have to do for necessaries? Two things. Remember? We have to have an issue of law and an issue of fact. The issue of law is to ask the question, is passage money a necessary? The fact is passage money necessary for this particular girl in these circumstances? So it's a question of fact. So let's see how they did it. They said the plaintiff, so Boychuk, the relative, had failed to prove that this was a contract for necessaries. Bad news for him, right? The defendant, the young girl, already had a job that was satisfactory by Polish standards. What are they telling us here?
Well, she probably already had a decent enough job. She probably could have just saved up the money and come.
That's the one. So they're saying she had a good job. So remember what they told us at the very beginning? She had a good job by Polish standards. Meaning what? Meaning if she needed money to transfer from Poland to Australia, she would have been able to save up for this money. The money that you gave her maybe made it easier to get here, but not a necessity. Okay. So this is the fact. So it was found in the comment. It was found as a matter of fact. So this is the question of fact, that the transaction was beneficial to the defendant. It was beneficial. Remember, necessaries, beneficial are all going to go into the same bucket. So it's valid. But here it says, but because the plaintiff failed to establish the preliminary question of law, the case was dismissed. So we said in order for you to establish that the money is a necessary, you had to go what? Through two things. Okay?
Question of law and question of fact.
So let's go back and look at that. This is what I'm talking about. Oof. Here. Okay. The court went through the elements. The first element was to ask, are the unpaid goods, what are the goods here? The transfer money, capable of being necessaries. This is a question of law. Okay. If you succeed on that, then you come to the next question. Is this money necessary in the particular circumstances? They said on this second part, the court said yes, because it's beneficial. But on the first part, they said no, because she could have saved up. Okay? Someone with a job, so if you take the girl out, someone with a job, a good job in Poland, would be able to save up. That money is not necessary for them.
Yeah, but it said by Polish standards, that could be much lower than... Okay, I don't mean to sound bad here, but that could have been much lower.
I don't know if it could have been, but this was back in 1961. Okay, Poland in 1961 was a communist country, but I wouldn't know really whether she would have been able to actually save up that kind of money or not. The court said she could have. Okay, so it means that they have looked at the standards and they thought that she should have been able to get that money from her job. Okay. Okay, let's look at page 284. This is the Hamilton case, High Court of Australia. And we're talking about beneficial contracts of service. But remember, this is 1912. The defendant, while still an infant, had entered into an article clerkship with the plaintiff. One of the terms of the agreement was that the defendant would not practice as a solicitor within 30 miles of Toowoomba, where the plaintiff had his practice. Another clause in this contract allowed the plaintiff to assign the articles to any other solicitor practicing in Toowoomba or elsewhere in Queensland. A year after the defendant had finished his articles, he commenced practice in Toowoomba, and the plaintiff sought an injunction to stop him. So, law as an academic discipline is very new. Really, it started probably, 20th century, This is 1912. But even then, if you wanted to become a lawyer, you would go do it like a carpenter, or like a profession. You have to go and work for a lawyer. You don't go to university as an apprenticeship. This is what we're looking at here. So this guy wanted to become a lawyer. So he went and got into this agreement for a clerkship. Once he finished his clerkship, now he's capable of doing, lawyering. I mean, even if you go look at the biography of someone like Abraham Lincoln, for example. He was a lawyer, same story, There is no formal education. You have to go and do it under a lawyer. Even today, after you get your degree as a lawyer, you still have to go and work at a firm, especially if you want to go for barrister or you want to do litigation later on. So the point is, this guy was afraid that once I teach you how to be a lawyer, you're going to compete with me. So he said, I will have to put a proviso, so a restraint of trade sort of clause, okay, that you are not going to practice anywhere in Toowoomba, 30 miles of Toowoomba. So 50 kilometers, that's what, Laidley? All the way up to Laidley. So the issue was, could the defendant, remember the defendant was an infant when they signed this contract. Okay? Could they argue that the clause or the clauses were so onerous that they outweighed the beneficial terms and that therefore the contract was not valid? Okay? The court said no. This contract, when taken as a whole, okay, was enforceable, even though we might agree with you that this restraint of trade clause is onerous. Okay? I wouldn't give you full marks if you do this in the exam. Because on the facts, that's not what we're talking about. What we're talking about is whether this defendant, who was an infant when they signed this contract, understood the nature, whether it's onerous or not, of the contract, including that restraint clause. Did they understand it or not? And the court said, okay, it doesn't matter, because it's of benefit to you. So the benefit by itself gives us an indication that you understood. You agreed to this contract because you knew you're going to become a lawyer. So the transfer of those skills in itself is enough to establish it's a beneficial contract. So something very much like a contract for necessities or necessaries.
So they decided that the contract was enforceable because even though the person was an infant, since they were studying to be a lawyer, they should have known what they were agreeing to.
So we said that there are two types of contracts that are valid even if you are a minor. There are the contracts for necessaries and the contracts that are beneficial to this infant. Let's look at an example of a contract that's valid, but valid unless avoided. Okay, so the default is valid. 285, and it is the Corp and Overton from 1833. This one. Okay. An infant agreed to enter into a partnership agreement with an adult and paid £100 as an advance. So they agreed for a partnership, and the infant paid that much as an advance. He then repudiated the agreement. What does that mean? So when you repudiate, you show the other party an intention not to follow through with this agreement. Always remember, there's something called the Australian Law Dictionary, which is available free online. Just go to the library website, and you can just type repudiation. You'll have a lot more on that there. And they did so they decided to get out of the contract. They are not going to perform their part of the agreement before they began operation. Very early on. So what do you want? What's the issue? Well, what do they want? What's the objective? They want the £100. They paid the £100 in advance, and now they don't want to go with the partnership. Give me my money back. Give me my money back. So what's the issue? The question was whether there was what we call a total failure of consideration. In this instance, we're talking about an infant, right? Okay. But in this instance, the analysis is not going under the agreement itself. The analysis is going under consideration. Remember, for a contract to be in existence, you need three things: the agreement, an intention, and consideration. Okay? What do they mean by failure, total failure of consideration? So they are saying, under this contract, did this infant get any benefit? In the previous one, okay, we looked at the one in from Tumba, the solicitor. We said that the person who went through this apprenticeship, okay, benefited because they became solicitors. They transferred the skills. The question, is there a benefit now to this infant from this partnership? And someone's nodding no. Why not? Because they decided to repudiate before the partnership began to operate. So if I want to put this in an exam question, I would just take out that part. Just cross out before the partnership began to operate. He then repudiated the agreement, full stop. That changes everything. And you need to spot that. The decision was the infant could recover the money, as he had repudiated the agreement before the partnership began to function, so there was total failure of consideration. If there is no contract, then the money I paid you must be given back to me, because there's no contract. But what are you going to keep the money for? However, if you take that part out, then there would be an argument, an issue, whether there was in fact total failure of consideration or not. Okay, let's leave that there. Let's leave that and move on to corporations. Actually, we're going to go to page 291 and talk about the mentally ill. 291. So let's look at Bloomley and O'Brien on top of the page on page 291 from 1956, High Court of Australia. Okay. Ryan was a 78-year-old alcoholic who, during a drinking session with Bloomley, was induced to sell his farm to Bloomley for much less than its market value.
Market value is how much?
Sorry?
By the less than the market value, it is assuming that the market value has improved significantly since Ryan purchased the land.
it could be, we'll just take it at face value. The guy wants to, if the farm is worth, I don't know, $1 million, they want to take it for 800,000, 700,000, something like that. A written contract was drawn up and signed. Okay, so this guy is 70-year-old, 78, and this is 1956. So 78 in 1956 was really old. Now 78 is not old, you know. You have to be like 98 in 58 years. A written contract was drawn up and signed. Okay. And Ryan later, of course, refused to complete the sale. So, what do you need to prove? Yes?
That Ryan was potentially under the influence of alcohol, so he was unaware of the contract he was signing.
Okay. So look back to your notes and tell me what are the two elements I need to prove. So the first thing, so let's see here.
Well, he didn't have the ability to understand, isn't that it?
Exactly. So if it's mentally ill, you have to have two things. You have to prove on the bottom of this slide that you did not understand what you were doing at the time, but also that Bloomley, was aware of their disability. What's the disability here? So it's the intoxication. Yeah. Disability, i.e. not being able to understand. So the question was, could Bloomley enforce the contract through an order of specific performance? So it's going to go to court and say, look, I have this contract. I want, whatever his name, Ryan, to go ahead and sell the land. So I still want the land. I'm going to pay him the 700,000, which, as we were told, is much less than the market value. So they said, this is what? The High Court. Ryan should be released. So if they elect to say, I don't want to go with this, I want to repudiate, they have a right to do so. Because to the knowledge of Bloomley, so this is the second element. They are saying Bloomley knew. To the knowledge of Bloomley, had been seriously affected by drinking, and as a result, his judgment had been seriously affected. This is not a good way of analyzing things. The first thing that they have to talk about is the second one. You have to say that he has actually been seriously affected by his drinking, that he doesn't understand. First element, tick. And the second element, that the plaintiff or Bloomley, the other side, knew that Ryan was affected by his drinking. So the two elements are satisfied. So if you are doing this in the exam, don't do it this way. Go through the elements. Element 1, element 2, and so on. We'll go through these after the break. All right, let's leave it there.
Question with that.
Yes?
Because that was both of the drinking session, could it have been argued that Blomley was not aware that he was seriously affected by alcohol? He could have been drinking for longer.
He could have been drinking for longer, but it doesn't seem to be the case here.
Well, it also said that Ryan was an alcoholic, so he might have been a heavier drinker than Bloomley. So
Okay.
he might have been a lot more he might have had a lot more drinks than
Yeah.
Bloomley.
So he starts at 10. So maybe he's someone different, you know. He went to this person already, you know, happy, you know, already intoxicated. You never know. But on the facts, it's saying that Bloomley recognized that this guy is intoxicated. He didn't know what he was doing, and still offered to sell or to buy his farm from him. If this was an exam question, of course, I'm happy for you to raise these points. Okay? But don't make that the centerpiece of your answer. And don't make any assumptions that are, you know, too far to the left or too far to the right. So make assumptions that are reasonable. Here we are told, so the facts simply say what? The way we wrote the facts, he was an alcoholic. There was a drinking session with Bloomley. which yes, would suggest that Bloomley was also drinking, but on these facts you could argue that if they were both drinking, so if I go with your argument, which one of the two elements becomes the legal issue? The first element that Ryan didn't understand, or the second element that Bloomley didn't know that Ryan didn't understand? Which one of those two then becomes the legal issue? The second one. The first one, he doesn't understand, there's no issue there. Of course, if he was drinking, he's alcoholic, definitely he didn't understand. But the problem for you, if you are Ryan, is to prove that Bloomley, while they were drinking together, they're both intoxicated, still, was aware of the fact that he doesn't understand, I'm going to trick him now into selling this farm. Can you do that when you are drunk? Not drunk. Can you do that when you are drinking?
Depends how much you have to drink.
Oh. So, people can drink and still be able to, reason that way, especially if they can sort of tolerate more alcohol than the other person. So if I take out Ryan and refer to someone like Rolanda, does that change anything in your argument? If it's not Ryan, it's Rolanda, it's a female, a 78-year-old female, a 55 kg, 78-year-old female, would that change things? Yeah, alcoholic, yeah.
Alcoholics would be able to tolerate alcohol better than someone who does not drink.
But a man would be able to tolerate more than a woman. See? So this is where I'm going with that. So these changes, if I do change the question and put it in the exam, that's what I'm looking for. Someone who can spot that that's a man, that's a woman. So what's the difference? Or someone who can maybe even throw in something more. If I said something like, so he was in a drinking session with a number of people, not just Bloomley. And I can throw something there to say something like Bloomley, a Mormon, for example. Does that change anything? Mormon? Okay. So that's what you need to pick on. Okay. How am I trying to change the facts so that I can throw it one way or the other? But if you just say what you said, okay, and you identify that the legal issue is the second element, you will get an HD. Okay. That's what I'm looking for. So I'm not looking for someone who just writes all the elements. So if you have a question about negligence, I don't just expect you to say, oh, negligence has existence of duty, breach of duty, causation. Okay, we all know that. It's in your notes. I know that. We all know that by now. What I'm after is what is the legal issue. And the legal issue changes based on the facts. So if you don't spot the legal issue, you're not going to pass that part of the question. So even if the question has 5 marks, you will get below 2.5. That's the instruction to markers. If they don't spot the issue, then there's nothing else after that to talk about. So whatever you write, you will get maybe 2 marks out of 5. That's part B of the final exam. All right. Let's continue with O'Connor and Hart. Again, an elderly farmer entered into a contract with Hart to sell him his land for a very low price. After the farmer died, okay, his beneficiaries, so the people that were in the will that received this farm or land, argued that the contract should be set aside. What are they trying to say here? Okay, he's just an elderly person. So, was this person mentally ill? That's the only way you could argue it, right? So we are trying to say this person didn't know what they were doing. This person didn't understand what they were doing. So there's no agreement. So a contract does not exist. How are you going to argue that? The only way is to say what? That they are mentally ill. They are mentally ill because of old age or something. So the court said the land sale in this case was valid. Why? The party seeking to avoid the contract had to establish both the incapacity of the farmer and that the other party was aware of it, or should have been aware of it, what we call constructive knowledge. However, the beneficiaries could not prove this, and so the land sale was held to be valid. So just the same two elements for someone who's intoxicated. First thing, that this person doesn't understand. This time because they are mentally ill. The second element is that the other party to this transaction knew or ought to have known that that person is mentally ill. They're saying they failed on the second element. All right. Look, I'm going to now switch to chapter 12. Okay? But we'll keep going. Yeah? We'll keep going for another maybe half an hour, and then we'll take our break. Okay. So let's start. Now we're talking about mistake, yeah? So let's start from page 296. And look at David Securities and Commonwealth Bank. David Securities, one of the appellants, entered into an agreement with the Commonwealth Bank for a foreign currency loan, okay, through its Singapore branch. You understand why they want to have a foreign currency loan? So when you are, for example, importing and exporting, and you want to hedge the fluctuations in currency, you'd go to the bank and ask them to give you the loan in the currency that you will need to buy your goods in. So this is their Singapore branch. So the Singaporean dollar. Okay. Part of the agreement provided that the appellants were to pay the bank in respect of its withholding tax liability on mortgage payments sent to the bank's branch overseas. The agreement provided that the appellants were to pay the bank in respect of its withholding tax liability on mortgage payments sent to the bank's branch overseas. Too complicated, we don't need to know what that is. It's all right. The full court of the federal court held that the provision in the loan for payment of this withholding tax was void. Okay. So the court basically said that this agreement to pay this withholding tax was void. That's not the issue. What's the issue? Were the additional amounts paid in respect of the tax by the appellants recoverable? So just like when we heard about the guy, the infant who wants to go into a partnership, they paid an advance of £100, something similar. But the money here was paid because of a mistake. And the mistake is about the effect of this act. Okay? Because it's about the effect of an act, it's a mistake of law. Okay? A mistake of law, not a mistake of fact. We're not talking about the car. Is it a Holden or a Ford, or it exists or not? We're talking about the effect of this act on whether we have to pay you this money or not. So, they say prior to this case, payments similar to this, withholding tax, had been thought to be unrecoverable. Unrecoverable. So what did they say? This was the High Court. The payments made under mistake of law should be prima facie recoverable. Okay. Prima facie means on the face of it. So without any further evidence. Okay. The tax was payable by the bank, not the borrower, and the borrower paid the bank only the amount necessary to cover the tax because the bank had represented, so in that sense, a misrepresentation, okay, that this, but this is innocent, that this was what the borrower was obliged to do. But the clause requiring the borrower to pay the tax was void. Okay. So the borrower didn't owe anything to the bank. So just as if we were saying the contract is void. We're not talking about the whole agreement, the whole contract. So we're talking about this clause. So why is it void? Because of this mistake of law. All right. Let's look at common mistake. 292. 298. Leaf and International Galleries from 1950, UK. Leaf purchased a painting. Okay. Leaf purchased a painting mistakenly believed to have been painted by Constable. So they think Constable was the painter, a famous English landscape artist. So he paints landscapes. Okay. It was bought from this gallery, International Galleries, for £85. When Leaf attempted to sell the painting 5 years later, he discovered the error and sought to rescind the contract to recover his purchase price. Rescind the contract, so he wants to cancel the contract, take your painting, give him my money back. Issue: was there an agreement over the question of quality and subject matter? Okay. Remember, this is a common mistake. Meaning what? That the buyer and the seller, they both thought that this painting was by Constable. That's the mistake. And they both made the same mistake. So the court said, on an action based on mistake, there was no error in what was handed over. How come? It was a specific picture. Remember, we said at the very beginning the courts are reluctant to interfere. Okay? Let's say fair. It was a specific picture. The parties were agreed on the same terms, on the same subject matter, and that is sufficient to make a contract. Okay? But look at the comment. The claim in innocent misrepresentation failed because of a lapse of time. So if we have an innocent misrepresentation, we said, what are your remedies? Can you go in tort? Can you argue that I can go and argue deceit or negligence? No. But what can you argue under innocent misrepresentation? Yes, anyone? Remind me, please. Your notes? You could go to the ACL. That's a very good idea. I like that. So if I get you this exam, this question in the exam, and instead of this 5 years lapse, we make it 1 year, then I expect you to see that there are two things you could do. You could argue under mistake, so the validity under mistake, or you could try to argue it as innocent misrepresentation. Huh? Different strategies. All right. All right, let's move on and look at Bell. Or rather, let's continue with Pritchard and Merchants and Tradesmen's Mutual Life Assurance Society. 1858. It said the beneficiary of a life insurance policy which had lapsed because of non-payment of premiums paid a renewal premium to revive the policy. Okay? So you have to pay premiums for the policy to continue to be in place, so you can benefit from it. This guy, after a stoppage, a lapse of time, paid a renewal premium. So now the policy is revived. Okay? This is a life insurance policy. However, neither party was aware that the insured had died prior to the payment being made. So just like the car or the unicorn, okay? We both think that this person is still alive, the insurance policy is still active. The question was the subject matter of the contract of a totally different nature to that which the parties thought? Because you need to establish that it was in order for you to rely on that mistake, in order for you to say that the contract is void. And they said the beneficiary was not entitled to recover under the policy, and that makes, of course, common sense. It's a life policy, and the person is already dead. While the premium was paid and accepted, so we have an agreement, offer and acceptance, upon an implied understanding, okay, that the party insured was alive. So both parties were laboring under a mistake. So, and it's a common mistake because they both thought the same thing. Okay? So we say the transaction was void ab initio, i.e. from the beginning, meaning that there are no rights and obligations whatsoever that would arise from that so-called agreement. All right. The other case is about mistake in relation to quality and relation to the quality of subject matter. I'll leave that. Let's go to mutual mistake on page 301. We're going to talk about Raffles and Wichelhaus. Wichelhaus had agreed to purchase a quantity of cotton from Raffles. Okay. The agreement was that this cotton is going to arrive peerless from Bombay. Okay. However, there were two ships of the same name sailing from Bombay, one in October. Okay. So Peerless is the name of the ship, Peerless. Okay. Peerless is going to take your cotton from Bombay and deliver it to, I think it was in London. But two ships were leaving. One in October. This is the one that Wichelhaus was talking about, because it's the earlier one that going to leave. But the seller was talking about the one that was leaving in December. Okay? Two ships, the same name, but different departure dates. And the question, of course, is whether we have an agreement. Okay? In order for us to have an agreement, you must have an offer, a valid offer, and a valid acceptance. And the acceptance, of course, corresponds to the offer. You can go back and look at the rules of acceptance to see how they formulated this issue. And they said this was void, ab initio, because on the reasonable person test, an objective test, okay, a reasonable person would not have been able to determine which ship the parties referred to. Okay. And we said that this is, what type of mistake is this? Is this a common mistake or a mutual mistake? It's mutual. Why is it mutual? Because I made a mistake different from the mistake you've made. But we both made mistake. We both made a mistake. My mistake was I thought that you were talking about the Peerless that's going to leave in October. Your mistake, you thought I was talking about the Peerless that was going to leave in December. So you made a mistake, I made a mistake, and it's a mutual mistake. Okay? Just like the cars. You know, I want to sell a Holden. You think I'm going to sell you the Holden. You think you think you're buying the Ford. Same story. So in this case, because there was a latent ambiguity, i.e. a reasonable person wouldn't discover what they were talking about, there was no meeting of the minds. Okay? Consensus ad idem. And if you go back and look at what we talked about in relation to the agreement, offer and acceptance, we required that consensus ad idem. Okay? So there was no mutual assent, so there was no agreement. Okay? No agreement. Let's look at an example of a unilateral mistake. Now you'll find that the discussion in the textbook will take you through the identity of the person you're dealing with. And they distinguish between whether it's face-to-face or otherwise. Look, let's just do one of these, and I want to take you to something else because I think it's also important. Let's look at Bolton and Jones on page 302. Okay, again, UK 1857. Jones normally dealt with Brocklehurst, who owed him money. Dealt with him, so they have these transactions, business dealings. Okay. Okay. So Brocklehurst owed Jones money. Okay. Unknown though to Jones, Brocklehurst sold his business to someone else. Their name is Bolton. Okay. When Jones sent a written order for goods expressly addressed to Brocklehurst, he thinks he's dealing with Brocklehurst. As usual, they have dealings, normal dealings. Bolton struck out Brocklehurst's name and substituted his own and then completed the order. Okay. But he did not tell Jones of the change of ownership. Okay, so far so good. Later, of course, he's going to go and ask Jones for payment for these goods. Now Jones refused to pay. Why? Because he never intended to contract with Bolton. Is that a valid argument? So the issue, did Jones intend to contract only with Brocklehurst? Okay. Or did he intend to contract with the business and whomever or whoever owned it? So was he intending to talk about one particular individual or deal with one particular individual or dealing with the business regarding of its ownership? There was no contract, okay, because this is unilateral mistake, yeah? Because Jones had no intention of contracting with Bolton. And Bolton knew, that's the key point, that's why it's unilateral. So the mistake here was what? Mistake is that Jones thought he was dealing with Brocklehurst. He thought he was dealing with Brocklehurst. Bolton knew that because he saw Brocklehurst's name on the goods that are being ordered. So that told him that this guy Jones believes he's dealing with Brocklehurst. So the two elements you need are there. Okay? But he assumed it didn't matter. He crossed out the name and put his name instead. So in this case, Jones was not liable to Bolton for the cost of the pipes. Now remember, this was in 1857. Okay. In this case, Bolton had to establish that Jones was aware of the mistake. In most cases, this is not a problem because the mistake has been induced by fraud. Okay. If you go back and look at the previous cases. In this case, Jones had sent a written order to Brocklehurst addressed to him by name. Bolton had fulfilled the order, but hasn't told Jones that he had taken over the business that day. Jones accepted and used the goods, believing that they had been sent by Brocklehurst, as Jones had dealt with Brocklehurst before and had a set-off on which he intended to rely. There was nothing to alert him to the fact that he wasn't dealing with Brocklehurst. Now, let's look at the reflection. is it correct to say that when an offer is made to a definite person, only that person may accept the offer? This is not very good, so let me rephrase it. I mean, really, 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 really. Why do you think the court came down with this decision?
Well, because I guess it was one of those things that was a mistake thing, and well, I guess although he wasn't mentally ill or under intoxication, there was a mistake made, and one person knew of the mistake, but he didn't say anything about it. He just it was that mistake. A was dealing with B, thinking B was C.
Correct.
B was aware.
Correct. But again, let's just unpack it from a reasonable perspective. What single material fact made the court believe that the contract has to be void? Why? Charlene, yes? He crossed out the name. He didn't inform Jones. Not quite. Let me go back and read it with you together, and let's see if we can spot what I have in mind. Okay. Jones, it's very short, right? Jones normally dealt with Brocklehurst, who owed him money. However, unknown to Jones, Brocklehurst had sold his business to Bolton. When Jones sent a written order for goods expressly addressed to Brocklehurst, Bolton struck out Brocklehurst's name and substituted his own, and then completed the order. He then he didn't tell Jones of the change of ownership that day. When he asked for payment, Jones refused to pay, arguing he never intended to contract with Bolton. What is the reason really that Jones doesn't want to contract with Bolton? Okay, so Damien says he has to pay for the goods. What if he was dealing with Brocklehurst? He doesn't have to pay for them. And why is that? Because he owes him money, and that's the point that we talked about at the bottom, the what? To this point here, to set off the amount against the debt already owing on Brocklehurst. Yes? That makes a big difference. If I'm going to deal with Bolton, Bolton wants me to pay him. He doesn't owe me anything. With Brocklehurst, there's money. He owes me money. So I expect to take the goods from him, and that would set off his debt against that amount. Okay? All right.
So Brocklehurst owed Jones money, but Bolton did it, and Bolton was charging him for services, but Jones was actually using the services as what? The payment?
Yeah, net off. So you set off the debt with the goods or the services. Yes? Let's look at page 305. And we're going to look at a case, which I like, called Hartog. Hartog and Collin and Shields. Okay. The defendants discussed with the plaintiff the sale of 30,000 Argentine hair skins. Okay, and that's the price. 10, whatever the D stands for. What does it stand for? Quid or what? 10 something per skin. Shillings? All right. The preliminary negotiations had proceeded on the clear understanding that the price was to be fixed in reference to each skin. So I'm selling you per skin, not by weight. Okay? Which was accepted trade custom. When the defendants put their final order in writing, they mistakenly, which is what we're after, wrote 30,000 skins at that price, but per pound. So weight. You see it there? It's the number 30,000, but they are going to sell it by weight. Okay? This is the mistake. This meant that the price was the equivalent of roughly 1/3 of what should have been if they were by skin. So count, okay? When the sellers discovered the error, they refused, of course, to supply the skins because they are selling it for much cheaper, and the buyer sued for non-delivery. The issue was was it reasonable for the buyer to have been aware of the mistake? Remember, in order for you to argue mistake, especially if it's unilateral mistake, it's just like when we talked about the intoxicated and the mentally ill. You have to show that it wouldn't have been reasonable for the other party not to spot that. Okay? They're saying the buyer should have recognized that this price is very low. So something must be wrong. Okay? So the decision started again from the trade custom. So this is our key point. Okay? Was to fix the price by skin. The trade in this industry was by skin, not by weight. Okay? And given that the early negotiations were based again on a price per skin, okay, the plaintiff must have realized that a mistake had been made. It makes all the difference if the reasonable person would actually spot that in fact there's a problem here with the price. Okay? All right. Let's continue and look at maybe some non-est factum. 307. So this is about Petlin and Cullen. Petlin, who spoke little English and could not read it, okay, granted an option to Cullen, an agent, to purchase land owned by Petlin. You remember options when we talked about options previously? After the option period expired, Cullen wrote to Petlin enclosing a check for $50 and a form to be signed by him acknowledging receipt of this $50 and granting a further extension of the option. Okay. So they are trying to negotiate buying and selling a land. Okay. The land is on the market. Many people might be, interested in buying this land. So the agent decided to take an option, saying what? I will pay you $50, okay, on the condition that you don't sell the land until I come back to you. And that expired. So he wanted to renew the option. So let's say it's for a week. Okay. So after a week, he sent another check for another $50 saying, keep it still for me for another week. Don't sell it for another week. Okay. And he sent him a form, okay, to acknowledge the receipt of the money, the $50, but also to grant this extension of the option. And it said, sign that you have received the $50, excuse me, but no reference was made to the extension of the option. So what is the $50 for? Anyway, Petlin signed the document without reading it. Why? Because he doesn't know how to read English. Thinking it was only a receipt. Cullen's principal subsequently, or I should say, Cullen's principal subsequently tried to exercise the option. Who's the principal? So this is what we will discuss in week 10. This is an agent-principal relationship. So this guy, Cullen, works for someone. He's the agent for someone. The principal now, because Cullen kept the land on hold for this principal. Now the principal wants to buy it. So basically he employs Cullen. Cullen works for him as an agent. Okay. We'll discuss this relationship much more in week 10. Cullen's principal subsequently tried to exercise this option, but now the seller, Petlin, refused to sell the land. Why? Why did he refuse to sell the land? I don't know. But this is the issue. Could Petlin show that what he had signed, that's the first element, was radically different from what he thought he was signing without showing carelessness? This is the second element. So this is not clean. This is not clean analysis, you know, putting everything together. They should, in fact, say something like whether Petlin could successfully raise the defense of non est factum. That's the legal issue. And when you analyze the legal issue, you would have to say that there are two elements. This is your thinking process. The first one is that this thing that they've signed must be radically different from what they thought they were signing. And I don't think there's a legal issue here because they thought they were signing a receipt. Instead, they were signing an extension, a new option. And then they should be able to show that there was no carelessness. This is the one that could actually be an issue, because if you don't know how to read English, is that a license to say, oh, I'm just going to sign it? Or would a reasonable person say, maybe I should have someone read it for me? Decision. The defense of non est factum, so that's where you have to, in other words, that's a better formulation. Could Petlin, plead non est factum and thus make the contract void? Okay, that's how you should do it. That's how you should do it in the exam. The second formulation, that's the correct legal issue. The defense of non est factum could be used successfully. Why? Because you can meet both elements. Petlin was able to show that he signed the document in the belief that it was radically different, from it was, so that's the first one, and that this belief was a direct result of Cullen's actions. He thought he was signing a receipt, while in fact he was signing an option for Cullen to buy his land. So again, it's not very tidy in terms of these two elements. So we're talking about the elements that we looked at on this slide. Just after mistake, this one. So the two elements, the document is radically different from from that which the signer expected, Petlin in this case, and the failure to read or understand was not due to carelessness or negligence. So you have to go through the elements, check which one of them might be an issue, and then find the conclusion. So it says in the comment, while it was normally necessary to establish that there was no carelessness or failure to take reasonable precautions in ascertaining the character of the document before signing it on the part of the innocent party, in this case, so they're talking about the second element, the question of carelessness was not relevant. Why? So they say Petlin's belief that the document was merely a receipt had been caused by Cullen. So if the other party is inducing you, I'm not saying fraudulently, but by something they said or something they did induce you to believe the nature of this document you're signing is very radically different from what it is, then the second element becomes less important. Okay? All right, let's switch gear and go to misrepresentation. I'm just going to pick maybe one of those. Okay. Okay. Let's go to page 314 and we'll look at Esso Petroleum. So misrepresentation, we're talking Esso Petroleum, and we're going to talk about negligent misrepresentation. Marden had entered into a 3-year lease of an Esso service station on the basis of statements by Esso's expert that the station would sell about 900,000 liters of petrol a year. Okay? So if you're reading this in the exam, immediately you can say, oh, statements. So something about misrepresentation. We don't know if it's negligent or not yet. This estimate of 900,000 liters of petrol a year was based on there being direct access to the service station from the main street. So look at the Caltex, for example, okay? So they're saying if you want to lease it, we expect that this is going to the turnover is going to be something around 900,000 liters per year. You're going to sell that much of petrol. And why? Because you're on a main street. So Ruthven Street, for example, okay? New England Highway. When the local council made a planning decision that would prevent direct access. Okay? So, change of plans by the local council. Esso continued to maintain that the throughput would be still 900,000 liters. This is how the statement became untrue. Okay? At the beginning, when they had this access to the main street, they were selling that much. Then something happened. The local council changed or introduced new plans that would prevent this direct access, which of course would mean that you would sell less. But Esso continued saying you would still sell 900,000. It subsequently turned out that the sales were substantially less. Okay? So now the sales are only 355,000. Okay? Less than half. So Marden, this is the guy who wants to lease the station, ended up being unable to pay for his petrol. And as a consequence, made a large loss. Okay? So Esso sued for possession and monies owed on petrol supplies, and Marden counterclaimed for breach of warranty. Okay? So this is under the contract itself. There's a contract, of course. So you can sue on the contract, a breach of warranty, but also as under negligence in torts, as negligent misstatement. This is not a good issue, but it says, was Marden entitled to rely on the skill and expertise of Esso? Okay. In our instance, whether there was a negligent misstatement by Esso would make more sense. And then you'd go on and look at the elements. Okay. And the elements are given to you here. Okay. Establishing negligent misrepresentation, you need the following elements. A special relationship must exist between the parties, such that the person providing the advice or information must be aware that the party seeking the advice or information trusts them to exercise a duty of care in the giving of the information. So here we talk about, of course, Marden and whether they trusted that Esso were experts in giving him this information. And then the subject matter must be of serious or business matter. This is not an issue. This is straightforward. There's no problem there. You can establish that easily. The person providing the advice or information must realize that the recipient intended to act upon the advice or information, of course, because that's what's going to get them to agree to lease the station. In the circumstances, it was reasonable for the recipient, Marden in this case, to rely on that advice or information, and the person receiving that advice suffered damage. So here, of course, we were told that they suffered huge loss, okay, monetary loss, as it said in the facts. So, the decision. The statements of Esso's officials were factual statements on a crucial matter made by those who professed, okay, to and did have special knowledge and skill, which were intended to and did induce Marden to enter into a lease. So they're going through the elements, but without telling you. As such, they amounted to contractual warranties. So this is the first part. This is about the contracts. Okay. We will talk more about warranties. We will talk more about warranties when we go to chapter 14. So don't worry, there's more about that. Furthermore, the circumstances were such that the statements of Esso's officials placed upon them a duty. Okay? So they started now the analysis under negligence, in particular negligent misstatement, to exercise reasonable care to ensure that the representations were correct. That duty of care was held to exist both prior to and after the signing of the contract. Okay? So, before getting into the contract, the statements were made. So you can't rely on contract law to say that there was a breach. That's before. But they were also made after the contract was made. They insisted that they would still be selling that amount. So they were liable for the breach of this duty. Okay? And they were liable under negligent misstatements. Negligent misrepresentation. So, the key point when I talk about misrepresentation, and I'll talk again about it in chapter 14, we're talking about something that's not a term of the contract. If Marden, for example, said to Esso, I want this statement that I will be able to sell 900,000 per year in petrol as part of the conditions, maybe it actually was because that's why he's actually suing under warranty, but that's how you do it. You have to put it in the contract that you actually promise me that that's how much I'm going to be selling per year as part of the contract. So if there is something wrong with that statement, it becomes a breach of the contract, or at least a breach of a warranty. There's a warranty and there's a condition. So we will look at what kind of remedies you can get out of that later on. This is an important part. So just to remind you that there's the ACL. We'll talk about it a bit more. Could the statements made in this instance also constitute misleading and deceptive conduct under section 18? So I'm asking you please just to read a little bit. I will go back to that later. But it is on page 215, the Australian Consumer Law, one page. Page 215, please read it. And I want you to link this to something on chapter 18. We're not going to cover chapter 18. But I want you to go and look at what they have on page 464. Okay? So page 315 and page 464. And we'll park it here for now. 10 minutes. 10:10. We'll come back and do our tutorial. Thanks.